So I have an admission to make. I wasn't the first choice of a speaker today. Tim and Adam were trying to get Miley Cyrus to come and talk about how to dress appropriately and act appropriately, but she was tied up with the MTV Music Awards, so you get me instead. So I usually, every day I try to learn maybe one thing, because that's about all I can sometimes comprehend. So my hope is, as you're thinking about getting out of here and going golfing, that I can give you 1 to 9 small nuggets that you can retain in your head. I do not have a PowerPoint presentation. I am kind of a dinosaur. I don't like to get on the line, as they say, and I'm not on the Facebook, so you're just going to have to bear with me as I give my verbal presentation. So number one, the first thing, there is a new case that you should all be interested in. It's an April of 2015 case, and it addressed the issue of, I have an employee who's an existing employee, and I want them to sign a covenant not to compete. And the open question until April of 2015 was, do I have to pay that person something additional, some additional consideration to have that covenant not to compete be valid? The answer from the Supreme Court as of April 2015 is you do not. The employee's continued employment with you is sufficient consideration or something of value to make that agreement enforceable. In legalese, I'll read you what the Supreme Court said, or a little snippet. An employer's forbearance in exercising its right to terminate an at-will employee constitutes lawful consideration for signing a restrictive covenant. In other words, if you don't terminate the person and say we're going to continue to employ you, you can force them to sign a restrictive covenant, an agreement that they're not going to compete with you. So that's something new and something you should be aware of. However, if you're going to have them sign an agreement, obviously you want to have something stated in the agreement about in consideration of continuing employment. I did not hear all of the former speakers, the last speaker's presentation, but I think my presentation is going to dovetail nicely with it, because I'm going to tell you, based on 20 years in the business, or 22 or 25, whatever it is, how you can almost assure yourself of getting sued. I think he was talking about all the good, the good measures to take, the best practices, but I will tell you what you can do to get sued, because I've seen all these examples are from cases I've actually had. So number one, do not retaliate. And here's a situation we see again and again. An employer complains to management or somebody in management about harassment or discrimination or not following the wage and hour laws. And that complaint can be a verbal complaint, that's good enough, or a written complaint. And what happens? Management or supervisors suddenly bad things happen to the employee, either from management or supervisor or coworkers. Can be blatant, such as there's a complaint and the employer says, you know what, I don't need this person, they're a troublemaker, they're going to cause problems, you're out of here. That happens sometimes just like that. Or their pay can be decreased, or they can be demoted. But also what you see again and again in the workplace is very subtle things. And here, these are all real life examples. A complaint comes in for an employee, all of a sudden their duties and responsibilities are changed. Or they're given the assignments nobody wants. Or management takes away the resources that are necessary for them to do the job. We've even seen where they put them in a, they take them from a nice office and they put them in a little office that's a closet with no windows. Or management tells people, you can't talk to that person, or the person can't talk to other people. These are all things that employers do. I know it's hard to believe. I know none of you would do anything like that, but it is amazing what you will see in the workplace with what these employers, well, what management does. I think it can be summed up by a case Tim and I had where it was a female HR manager, and she complained about sexual harassment by the executive director, and he admitted this, that, well, he didn't admit that he did it to her, but his little mantra was, when we want to get rid of somebody, we alienate, isolate, and make them so uncomfortable that they want to leave. And that's what they did to this gal. So, number one, if you retaliate, the employee may very well litigate. Number two, do not make stuff up. about the employee in performance documents after the employee is let go. And again, you would not believe this happens, but we have seen many times, because the first thing that employees do when they hire an attorney, the attorney says, go get your personnel file. And you all know, I'm sure, you're required by Wisconsin law to give the employee the personnel file. And the reason attorneys say get the personnel file is they want to get it frozen in time, because oftentimes employers will take things out of the personnel file that are positive, or will add things in the personnel file after the fact that are negative to justify the termination. And let me give you some examples. One that you often see is warnings that are not signed by the employee. And obviously, if you're giving an employee a warning, you should have them sign it, because otherwise, if you get into litigation and they get the personnel file, they're going to say, I didn't know anything about this warning. You have a section right here that says employee's signature. I didn't sign that. I never knew about this. Warning signed on the employee's behalf. We've had cases where after an employee is terminated, we get the personnel file, and the employer signed on behalf of the employee. Again, that doesn't look good when the employer is signing the employee's signature. Third, we often see warnings that are backdated. An employee is terminated, and all of a sudden there's something that actually occurred in August, and it's backdated till June or whatever. You want to have your performance documents done timely, signed by the employee, signed, dated timely. You don't want to go back in and recreate things after the fact, because if you ever get in a dispute, it looks to whoever's looking like you're doing something funny. You're cooking the books to justify something that wasn't done properly. And what happens is, the employee requests the personnel file, they see it, and they say, this was never in there. That's fishy. I never signed this. I never saw this. And then they go to an attorney sees that, because that's the first thing the attorney looks at. They're saying, boy, there has to be some improper thing going on here, because the employer didn't have the employee sign these things. They added things after the fact, et cetera, et cetera, et cetera. And that goes to this whole performance documentation thing. I don't know what the gentleman before me said, but oftentimes employers say, well, we had a long history of performance issues with this person, this guy or this gal, and I'm an attorney looking at that, and I'm saying, well, I looked at the personnel file, where's the documentation? Because the law says you're supposed to keep this documentation in the personnel file. Well, we kept it in a file cabinet, a separate file cabinet that I just kept on my own, and management didn't know about it, and HR didn't know about it. That's problematic, because what happens is you get the personnel file, then later on the manager says, well, geez, we had all this performance-related documentation over here, and it wasn't in the personnel file, and the first thing that happens is the employee and the employee and the attorney think there's something fishy here. It should have been in the personnel file. So if you fabricate documents, the employee will litigate. Number 3, do not badmouth a terminated employee. It sounds simple enough, but time and time again, after the employee is terminated, the employer or supervisor drags their name through the mud. In the case of public sector employees, the employer talks to the press and says bad things about the employee. I've had 2 cases now with counties where the employer could have just said nothing. Instead, they made statements in the press that are arguably defamatory, are going to affect the employee's ability to get a job, and all of a sudden you're going to be in a big lawsuit because you published and the newspaper published these statements about the employee. It's usually high-level management employees in counties and cities, but I've had 2 cases. One case involved Barron County. It went on for 4 years, 2 Court of Appeals decisions, and finally got resolved, but it involved the county administrator who just didn't need to say anything, said he went out because he made him felt good and said things about somebody who was terminated, and that's what you get. So that's the saying derogatory things to the press, also talking to coworkers and saying derogatory things, and finally talking to prospective employers and saying derogatory things. I don't know what the gentleman before me said, but in my opinion, there's no reason when a prospective employer calls you and asks you questions about an employee you terminated, to say anything negative about that employee. There's just no reason. Best practices, good management practices, and this is kind of the chicken's way out, but it's to say our policy is to tell you the position held and the dates of employment and nothing else. You cannot get in trouble if you say that. But many times an employer is a little bit ticked off about what happened with the employee and feels they want to get back at them a little bit, and they say certain things. And the employee knows, believe me, they know, because the employee calls me and says, I can't get a job. I'm pretty sure they're saying bad things about me. And if the employee is able to verify that, then all of a sudden you have a case against you for defamation or interference with contractual relations. Again, there's absolutely no reason with an employee you've terminated that you need to say anything more than this employee worked for us for this long in this position. There's no reason. So if you propagate bad things about the employee, if you badmouth the employee after they're terminated, they will litigate. Number 4, Tim was talking about this, is if you want to be sued, ignore an employee's complaints of harassment or discrimination or violation of other laws. And it happens because people do not like to deal with difficult situations. People do not like conflict. They would rather hope that the situation just goes away. But it oftentimes does not. And if the employer buries their head in the sand and hopes it will go away, and the employee says after 2 months or 6 months or a year, you know what, I've had enough. I can't take this anymore. And I know you don't, you have to put yourself in the employee's shoes a little bit. If they're being harassed by a coworker, if they're being discriminated against, and they're living with this every day, it's terrible stuff. They're anxious, they're depressed, it affects their home life, and eventually they just throw their hands up and quit. And then they say, you know what? I'm going to treat this as if you terminated me. It's called a constructive discharge, which is if you as an employer treat the employee in such a manner that any reasonable person in that employee's position would view the situation such that they needed to resign, that the position was intolerable, then the law will deem that to be equivalent, will treat that as if you terminated them. So if you bury your head in the sand and hope it goes away, and the employee quits because it's too much, and a reasonable person would have quit, and you're sued, it's not going to be a defense that, hey, we didn't terminate her, she just went away. It's going to be treated just like you had terminated her or him for illegal reasons. So what should you do as an employer when something comes to your attention? 1, investigate. Have somebody investigate what's going on. Attorneys can help you, HR people can help you, but you need to do something in terms of talking to the employee, talking to those who are accused of doing the wrongdoing, and then you have to keep the employee informed and tell the employee, hey, we're trying to do something about this. And then you need, if it's determined that the employee is being subject to harassment or discrimination or retaliation, you need to take prompt remedial and or corrective action. Number 5, in ways to get sued, withhold payment of wages or accrued benefits at the time that the employee is terminated. Here's how this comes up. Sometimes in the factory setting, the employee is terminated and the manager says, well, they screwed up on the line and we're going to withhold $200 because they screwed up on the line and damaged the machine, or they didn't get all the work done. That's almost a surefire way to end up being sued. What will happen is the employee will file a case with the Department of Workforce Development wage and hour people, and all of a sudden you're in litigation. The other way is if they're entitled to accrued vacation or sick time or PTO, and that's a matter of the law is, in the default, unless your handbook says that they're not entitled to PTO in the event of termination, they're entitled to it. So first of all, if you're going to have a penalty where if an employee is terminated, that they're going to forfeit accrued vacation or sick time or paid time off, you ought to have that in your handbook. So if you don't have that in your handbook and they have accrued PTO and it's withheld at the time of their termination, that's problematic. You can either end up in again with them suing, but usually what happens is it's just that trigger that makes employees mad. And employees sue because they feel they're being treated unfairly. And so employers a lot of times do these little things to kind of get it on the back end. We're going to get rid of the PTO, or we're going to do this withholding. But if you do that, you're increasing the chances of the employee thinking they're being treated unfairly and suing. Which gets me to the next one, challenging unemployment compensation. I have been to many unemployment compensation hearings, both on behalf of employers and employees. Some employers, as a matter of course, challenge unemployment compensation. And there is nothing that ticks an employee off more than challenging unemployment compensation. The number one thing that causes employees to go to attorneys is if their unemployment compensation is denied. I'm not saying you shouldn't do it. There are some times when you should challenge unemployment compensation. An employee steals from you, okay, challenge. An employee assaults another employee, that's fine, challenge it. An employee is directly in subordinate, challenge it. The standard, as you probably know, is a fairly high standard for when an employee doesn't get unemployment compensation. A willful disregard of the employer's interest or substantial fault connected with employment. And so why, as an employer, are you going to challenge unemployment and increase the employee being upset with you, increasing the odds of the employee seeing an attorney and filing some discrimination case if the chances of you winning are minimal? So again, I'm not saying don't do it, but take a serious look at, does it really make sense? Many times an employee just has poor performance. Poor performance alone usually is not enough to justify challenging unemployment. Because here's what happens, for those of you who have gone through it. The employee files the application for unemployment compensation. The employer puts in the response saying, here's what happened, and whether or not they think it should be paid. And if it's denied, you're going to have a hearing before an administrative law judge. The hearing before the administrative law judge is a hearing where people are sworn in, evidence is taken, exhibits are offered, and it is recorded on a CD. And so if you're sued later on, if you go to state court or federal court or Equal Rights Division for the state of Wisconsin, a savvy employee attorney will get that CD, have it transcribed, and you're stuck with the sworn testimony about what you said at that time about the reason for the termination. And so that can be used against you from day one, and you might send somebody in who shouldn't even be sent in to testify about the unemployment compensation, but you're stuck with that position. And so there are a lot of pitfalls to challenging unemployment compensation. One thing I'd say, if you're going to do it, you better make sure you have the reason down pat, and that's a reason you're going to stick with, because it's pretty hard after you had your representative go into the UC hearing and say this is the reason somebody was terminated. 2 years later on, say, oh, that was wrong, it's some other reason. Oh, here's the other one. And again, it all comes down to treating people fairly, because if they feel they've been treated fairly and humanely, they're much less likely to sue. Here's the best one. An employee is terminated in the middle of the day. They've been there for 20 years, and then they are escorted out of the office in the middle of the day where all their coworkers can see them after they've been forced to stand there and pack up their belongings. And that happens many times, and it's just humiliating to the employee. And the employee will often say, you know what? I was okay with being terminated, but the way they treated me after all these years of loyal service, that is the thing that caused me to come into you. They humiliated me. And so it's those little things that an employer sometimes doesn't think about that cause employees to sue. And the last thing, I'll skip that one to get to the steps, the proactive steps. So I'm a movie guy, and I'm going to, do you guys remember the movie? Everyone knows Patrick Swayze, right? The guy who, remember him in Roadhouse? So this is my Roadhouse Patrick Swayze example. He was and it's a good movie to always watch because it kind of brings me back to the 80s. So remember, he was the cooler And then they had the bouncers. And he said, if a customer is out of line, ask them to stop, but be nice. And he said, if they don't stop, ask again, but be nice. If they still don't, escort them to the door, but be nice until it's time to not be nice, and I'll tell you when it's time to not be nice. And that's what you need to do with the employee. At the termination meeting, be nice. When you're getting their personnel belongings, and escorting them out the door, be nice. When they ask for their personnel file, don't delay, don't make them pay $100 because you can charge them for it, be nice. When they apply for unemployment compensation, be nice. Until they sue you, and then you need to get the cooler Patrick Swayze, which would be some attorneys, to help you not be so nice. But really, if I could say one thing, is be nice until it's time not to be nice. Now, part of not being nice is, well, I don't know if that's, I wouldn't say that. Before the termination, I think it is prudent for you to sit down, you owners, you HR people, management, to sit down and review whether or not there are risk factors that this employee might sue. What's a risk factor? Well, they were just on FMLA, and they just came back, and it's 2 weeks since they came back from FMLA, and you're going to terminate them. That's probably a risk factor. What's another risk factor? Well, they just disclosed to you that they have a disability, and a month later, all of a sudden they have performance issues, and you're going to terminate them. That's probably a risk factor. All right, another risk factor. The guy or gal's been with the company for 30 years, and they've had great performance reviews for 29 years. They get a new manager who's somewhat younger, and all of a sudden they're the worst employee ever. And by the way, you're probably going to replace them with somebody who's 20 years old. That's probably a risk factor. My point is, if you sit down with HR, you should look at all those issues. Are there risk factors like age or gender or disability or pregnancy or FMLA that are likely to end up causing the potential of us getting sued? Because you need to make sure you have a legitimate, non-discriminatory reason for the termination. And so I would ask the manager or the HR person, what is the reason for this termination? Do we have documentation that supports the termination? And sometimes if you're really concerned, because I'm going to tell you, if a person comes back from being on medical leave or pregnancy leave, they were a good employee, and within a week of them coming back, they're terminated for some performance issues, you're going to be sued. No question about it. So you need to make sure you've talked to the appropriate people and feel you have justification, legitimate non-discriminatory reasons for the termination. All right, now my second movie example. You all seen The Godfather, right? And maybe some of you haven't, but you should. It's a very good movie. So in The Godfather, Don Corleone, he gets, there's an assassination attempt on his life, and his sons, Michael Corleone and Sonny, and then the Consigliere, the legal counsel, are sitting around in a den, and the one son is a real hothead, Sonny, and we're going to go to war, we're going to kill this guy, blah, 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 blah. And the counselor said, Sonny, this is business. It's not personal. And that's what you have to remember when you're dealing with employees and we're terminating people. It's business. It is not personal. But I will tell you that many managers and HR people get personally vested in the conflict. They make it personal. They want to win. So you need to step back and be objective and remember, this is business. It's not personal. All right. The next little hint is, and I think you got this from the prior gentleman, is be accurate and thorough in your performance evaluations. And I think we all have a tendency to be too nice. Most of us don't like conflict, and we want to be nice to our employees, even if it's objectively not supported. And what the problem we see is managers and HR people who overstate strengths and minimize weaknesses. And let me give you some examples. We had a case where a manager said, I would trust this person with my life. This was in the performance review, okay? Then we sued, and that was our client. He said, I will trust this person with my life. It's pretty hard after you put that in a performance review to go back and say, well, geez, that woman is a liar, because you just put that in your performance review. Maybe it's a nice thing to say, but that type of statement. Or, for instance, right before termination, a manager says, this person's productivity is excellent. Then after they're terminated, well, geez, they are terminated for poor productivity. Again, if it's not true, don't put it in. Don't overstate strengths and don't minimize weaknesses. Another example we've seen is this person gets along great with coworkers. That's in the performance review. Well, what happens when the person's terminated? Well, the reason for termination was poor relationship with coworkers. Again, be objective. Don't maximize, don't overstate strengths, and don't minimize weaknesses. 3 other comments. 20 years ago when I started in this business, email was not prevalent. Now, everything's an email. And so 20 years ago when we got involved in cases, there was no email track of communications between managers and communications with coworkers. It was all hard copy. Now we'll get involved in a case and there will be many things in email and many things that shouldn't have been said in email, because you can go back and get emails. And so many people think, and management employers think, well, geez, we'll put it in email. And you know how people are. They feel comfortable putting things in email that they wouldn't say to people. I don't know why, but those things all will come back. And so if you're an employer and you're talking with your other managers about here's the reason, what we're going to do with this person, emailing back and forth. If you're in a lawsuit, that is all discoverable. That will all come out. The nasty little comments you've made about the employee, and believe me, supervisors make nasty little comments, that's all going to come to light. So you should think as employers and as management people, and you should train your employees and management people that don't put it in an email if it's going to look bad or if it's inappropriate, because the emails will be recovered and it will make you as an employer look very bad. 2 other things. An ounce of prevention is worth a pound of cure. And so when we're representing employers, and there's an issue with a terminated employee, I routinely, and I don't know if other employer attorneys do this, but I routinely say, get a resignation and severance agreement, pay a little bit of money to the employee, and have them sign a document saying they're not going to sue you. You would be amazed where up front, before the employee gets an attorney, if you give them a severance amount of $500 or $1,000 or $2,000, a couple weeks of insurance coverage, they'll sign an agreement saying they'll never sue you. That is enforceable, and it goes away. You don't do that, you have some of these risk factors. They go to an attorney. You can be involved in a $100,000 or a $200,000 or a $300,000 case where you could have got it resolved up front for $500 or $1,000 or $2,000. And that's not just the money of you paying attorneys and potentially paying a judgment. The problem with these lawsuits is you're all in business, and it takes away from your productive time of the business and your thinking time and your people time, because that's what you're in the business of doing. So if you're sued because you've done some of these things, you're going to be spending time with your co-managers, you're going to be spending time with the attorneys, and that's going to take away from your business. So I advise, always talk to an attorney about whether or not, because there's risk factors present, it makes sense to consider some type of severance agreement and release. And finally, there is insurance called employment practices insurance that covers you or can cover you in the event an employee sues you. Depending on the size of business, I think it's always something that's prudent to consider. It's not that expensive. There's different insurance. Some covers judgments, some covers attorney's fees. but that's something you should at least look at and consider. And so I think I'm done and out of time. Thank you. Enjoy your golf today. I'm going back to the office because some attorneys at Bakke Norman have to support the other attorneys who golf. But I think you're going to have a great day for weather, and it was good talking to you today.